Hello friends, in the recent judgment, Supreme Court upheld the decision to demonetize some currency which took in the year 2016. On 8th November 2016, after getting the approval from the Council of Ministers, our Prime Minister has announced a demonetization exercise. In his words, to break the grip of corruption and black money, we are deciding the 500 rupee note and 1000 rupee notes will no longer be legally tendered. After that, we have taken up the demonetization exercise and we have replaced it with the new notes. But some people have started identifying some problems in this decision. One is related to the intended objectives and also what we have achieved. Second one is the legality or the procedural lapses involved in taking the decision. Obviously, in the case of first one, the Supreme Court cannot looking into because it's a policy decision. But Supreme Court certainly looks into the decision related to legality of demonetization. And many people approach the Supreme Court, and while delivering the judgment on the Supreme Court has made some interesting points. What was the authority that allowed the government to demonetize the currency? That is Reserve Bank of India Act section 26 clause 2. It reads, with the recommendation of the RBI board, union government through a gazette notification can declare any series of banknotes of any denomination shall cease to be legally tendered. Now the petitioner asked the Supreme Court, the recommendation of the Reserve Bank of India board is required. That means the decision should emanate from the Reserve Bank of India board. Second one, and it is talking about any series of banknotes of any denomination that does not include all the series of notes of a banknote of a particular denomination. So you can't issue it through a gazette. There must be an amendment to the act, and we did this amendment when we demonetized earlier, that is in the year 1946 and 1978. And third concern is there was no proper consultation between the Reserve Bank of India and the Government of India. But Government and Reserve Bank of India come up with their own explanation. We have not passed the legislation now, we have passed the legislation earlier because in earlier two instances RBI board not approved the decision taken by the government or the proposal of the government. That is why government went for the amendment of the legislation. And when it comes to the consultation, they have clearly said that there was at least 6 months consultation process was occurred prior to the taking of decision. Now in this judgment, with a majority of 4:1, Supreme Court upheld it, and Supreme Court said that there was proper consultation took place between the government and the Reserve Bank of India. And when it comes to the proportionality of a decision, Supreme Court said that there is a reasonable nexus between the objectives and the means we use to achieve the objectives. So I can't set aside this decision just because it's not proportional. And another important thing is it is related to all the series of currency notes. Under this particular provision, the government is empowered to demonetize all series of notes of a particular denomination or any denomination. And moreover, when it comes to the intervention by the judiciary into the economic aspect, it has clearly said that there must be a great restraint when we looking into economic policies of the country. And Supreme Court said that judiciary cannot supplant the executive wisdom. With its wisdom, it is not correct. And another important thing is the decision cannot be set aside because just the procedure has not emanated from the Reserve Bank of India. Though it is emanated from the government, but Reserve Bank of India board has its given approval, so this decision is proper and procedure is valid. Thank you.
Amrita IAS Academy.